as my radio signature, I'm a radio journalist. LPR is a matter of grave concern, and I want you to understand how the law operates as against them operating here in Hamilton County. LPRs violate the Constitution because they violate the crossing of a barrier by the police power. LPR, license plate reader. The barrier that's crossed by the police power as against your rights. It's a line that he can't cross. The Sheriff Austin Garrett cannot cross the line. He cannot cross the line to create a criminal ledger and effectively and implicitly make of you a criminal actor just awaiting their opportunity to apprehend you. That's what LPR is. LPR creates a criminal ledger. The purpose of the LPR purely is crime suppression, crime opposition, maintenance of the peace powers that the sheriff has. He has these powers. They're maintenance of the peace powers, not law enforcement. Which is different. They're maintenance of the peace, suppressing riots, affrays, disorders, perturbations, public disturbances, those kinds of things. Those are his lawful powers, though we know that he and all police departments operate under a different premise of law enforcement, which is separate. Law enforcement is not constabulary of the peace powers that sheriffs have. Okay, and so LPRs help the sheriff cross the boundary. What is the boundary? The boundary of reaching you with police power has to be a sworn affidavit, a criminal complaint, an indictment. The officer has to see you committing an act that is identified as a crime. You have committed it, you're in the middle of committing it, or you're about to commit this crime, gives him police power against you to stop you, right? To create a pre-case. A criminal case begins judicially when there's a hearing determining probable cause. But until that time, the officer creates a case, kind of imaginary, until the judge approves that a case exists, a charge has been made against you for a crime, and now we will proceed in court. The threshold that he crosses is to create the criminal case, not just of you, but promiscuously of everyone. Everyone is a suspect, and he is stalking your movements to obtain evidence against you. And there's a presumption of criminal acts, a presumption of crime in the operation of this crime suppression equipment. Okay, it's digital. It is not the misuse of the equipment that is important. Okay, we all hear YouTube, we see on TikTok many reports of stalking by officers, accidents in misreading of numbers. The I is a 1, and some poor woman from Clarksville is arrested and extradited to Idaho or Montana. Maybe you've seen that story. She was in the jail 2 months from an error on a facial recognition image in a store. So AI, which runs these systems, makes mistakes. License plate reading mistakes also are common, and glitches in the data are common to create arrest situations. Arrest is and should be a complicated and troubling activity for the officer to go through. The officer should not easily be able to make an arrest. It should be a big deal. It should take a lot of time. It should be a hassle. It should be a headache for an arrest to occur. So in dealing with the flock problem of sort of mass pre-arrest data collection on you, there's another problem that I'm hoping to address in court. I've got 2 lawsuits planned. One is against general warrants. General warrants is from the time of the colonies, where the British and the Redcoats would be able to seize anybody for cause without a warrant. If it was a search warrant, the search warrant would be general. It would not specify what's being sought, and it would allow the troops to go into a house or a building and take what they wanted to without having judicial authority ahead of time. Our system of law, based upon a reaction against these abuses, requires judicial approval beforehand. Crimes are determined to be extant beforehand by the judge, giving the officer the authority to search a place, naming the thing to be searched for, or to seize a person. Again, the person named and the cause for which he's being arrested also named. So flock is an extension. You have general warrants here, again, on the spot arrest for cause without a warrant, and really often without probable cause. And the extension of it is over here. The extension is the digitization of the process, making it much more efficient with the surveillance system. Again, the systems are very deep, and their database feeds and the interconnection of databases are myriad and improving all the time, thanks to groups like Palantir and others who make a profit on surveillance and in military applications by the Israelis, for example. Flock and related systems are abusive of your constitutional guarantees. In Tennessee, we have flock. In some cities have hundreds. We have in Hamilton County, I've looked at the contracts, at least 24, but probably more. I see them cropping up all over, and people on TikTok are telling me that they are seeming to be multiplying all over. And we're not talking here about corporate giants like Lowe's and Home Depot that have them in their parking lots, which they do. We're talking about those that are on public property run by the public authority, the Sheriff's Department. So there are any number of them, and the depth of interpenetrating powers in the background among all the databases, federal, ICE, immigration control, other groups that are looking out for dissidents, terrorists, people like that. There are all kinds of people who have access, and they can find you by your tag. They just type in your name on one database and find your tag on the other, and they know exactly where you've been. They can make a heat map of all your travels. And again, these are misuses of the systems, okay, many times. Outside of authority, outside of protocol, but it's not, for our interest here, it's not the misuse that is in view and what we can be concerned about. We can be concerned about and should be worried about the use of, that's because the Constitution forbids these systems from operating. Because again, they're not just commercial gathering of data about your travels so we can send you better ads. We notice you pass this Subway shop 3 days a week, so we're going to make sure that next time you pass that shop, you're going to get a free ad on your phone or on your next website search. There'll be a free ad for that shop because we know you pass that shop 3 times a week. That's commercial use, and we all kind of accept that as good service, personalized advertising for our interests and our location. That's generally, most people accept that. But the use in a criminal system of surveillance, a criminal data mining operation, is different. Okay, once the state gets involved in it, whether directly or indirectly, you have a violation of your God-given constitutional guarantees intended to keep you free from inquiry and oppression and harassment and interrogatories. Why? So that you can fulfill your duties under God. Christendom, the free market operates on people being free to come and go, to serve their neighbor, to save their neighbor, to provide secular salvation, whether it be computer repair, plumbing repair on a leaky pipe, or accounting services, all the things that are the free market, and also, of course, the gospel going out with all these things. That's what we're here for. That's why liberty is important, so that we are free to serve our neighbors, to die to ourselves, and look out for our other people, whether in a business relationship, personal service, or personal necessity or obligation, like taking care of your own mother in a nursing home. Those are all things that are necessary for us to expand the kingdom of God, expand Christendom, increase the operation of grace, which is what Christianity is all about. Increase the operation of grace among all the people around us, whether they're saved or not. Grace operates in common grace, and there's also particular grace. Our rights are worth preserving for those reasons, because it increases. If we have more rights, there's more capital creation among us. So flock and police surveillance suppress that liberty. and they create cause in any turn to go after Miss Glenda. We think Miss Glenda is a disturbing force for our polity out of Nashville or in Washington, and her friends too. So we need to kind of keep track of these people because they may turn against us. And if you're a tyrant or a despot, fear controls what you do. You're always afraid. You're continually finding enemies. You're continually finding people that might be against you, and they've already made some negative statements on Facebook. And so their concerns are myriad in Nashville with their fusion centers, their continuing mining of social information, public information, commercial information. They buy these things. But there's an important case from 1866, Cummins versus Missouri, that says what the government cannot do directly, it cannot do indirectly. If the state, in whichever form, is forbidden from acting one way, it can choose an alternative way of doing it. In other words, it can't hire out for the service of surveillance and surveil Dr. Adams. Can't do that. So I'm planning 2 lawsuits. One, I just came from the public library and got my affidavit of support notarized. It's against the sheriff. It'll be in Chancery Court, and it's called a petition for declaratory judgment. In other words, I want the judge to say what the law is. And I have standing to sue. I was arrested under the general warrants program of the sheriff for a damaged taillight. That was 2023, November 22. Damaged taillight brought me to the jail. And the argument is, well, that's not a public offense. I had to be arrested under a warrant. So in other words, you had to let me go, officer, go down to the jail, swear out a criminal complaint of a criminal nature that my damaged taillight was a crime and affected the public interest, then come and find me either at my studio or my home or in a restaurant getting a coffee, and then make the arrest lawfully. That's what has to happen. So the general warrant system means that we can seize you for any misdemeanor offense, even though that offense is not a public offense. Okay, remember, we've got there's a division here between LPRs, which is the extension of general warrants, and general warrants over here, which is the ability of a cop to make an on-the-spot arrest without a warrant. And my first case that I'm planning on filing in Chancery highlights the fact that the sheriff's duties are crime suppression, the suppression of affrays, riots, disorders, breaches of the peace, things of that kind. Now, many offenses that they make these arrests for are paper crimes. How has a damaged taillight had a public effect? The public offense standard that I'm suing to uphold says that a public offense is one that has a known effect upon Glenda or upon Miss Yoder. Miss Yoder was upset that I had a damaged taillight. In fact, she felt for her personal safety, and she recoiled seeing me pass by my car with a damaged taillight. Now that's a public offense. If Miss Yoder had the feeling that I was offending her and threatening her personal safety with that damaged taillight, well, that's grounds. Okay, then it becomes a public offense. But we all know that that's not how a blinker tag light operates on anybody who sees it. Or if someone is traveling in a car with a revoked license or a suspended license or a tag, we know that no one cares. I mean, no one's going to be shocked that tag is out of date. Man, I'm reeling because that tag is a year out of date. Well, man, I better call the cops, right? We know that that's not the kind of offense that the sheriff has to suppress. Okay, he suppresses riots. And so the fact that he has converted, and they've defended this already in federal court against me, they convert the phrase public offense into any offense. So they now have total arrest authority without a warrant ahead of time. And what they do is they arrest you without a warrant, hope for the best. If the judge dismisses the case, well, too bad. You got arrested, you got taken to jail, and well, we were wrong. The reason the warrant has to issue ahead of time is that that kind of offense doesn't occur against you, the citizen, because your rights of movement are sacrosanct in our law. Your right of free movement, free ingress and egress from your place of your abode is holy. Okay, it's effectively holy and is protected. And so it can't be that you can be interfered with on your mercy mission. which is just going to work, right? You're going to work as a mercy mission. You can't be interfered going to the radio station. I was on press business traveling in my car. And how dare they interrupt my press function? My show got canceled that day. So we want to make sure that when they make an arrest, they go through the trouble of alleging that that blinker tag light, which is subject to the Department of Safety and not to the Sheriff's Department, by the way, that blinker tag light, if it is a crime, that we prosecute it as a crime by going all the way down there, letting the accused go. Heaven forbid we have to go find him. Yes, you have to let him go. Get that warrant, but you have to write out a complaint. You know, the deputy has to go down there, has to draft the complaint of a crime. And it has to have all the essential elements of what the crime is, that for legal sufficiency. And then he has to get the judge to agree. The judge can't help him write it. The magistrate behind the glass window in the jail cannot help the officer to write the complaint. If the judge accepts it, then he signs it. Now the deputy is protected legally from clawback by his accused. If it's a bad arrest, well, that's not the deputy's fault. So I market my lawsuits as I'm pro-cop. I'm defending the deputy's personal estate, his family, his fishing boat, his extra car, his land, his house. He has a bit of farm property out in Ray County. I'm defending that because I'm going to sue him for those things because he put himself out and his personal authority to have me arrested without judicial approval ahead of time. That's what the warrant is for, is to protect him and to protect you, so that the judge, using the judicial function, properly assesses that yes, that tag light was a crime, yes, you can arrest him for that. That's what has to happen in every case like that. My thinking is, in the first lawsuit against general warrants, I call them Redcoat warrants, that lawsuit will end many of the oppressions that relate to it, including LPR. LPRs is, like I say, an extension of this general authority. But if the law is upheld, only real crimes will be prosecuted. These bogus crimes which afflict the poor more than any other kind of person. African Americans, Hispanics, poor people. I mean, I'm poor. I have old cars. Scandalous looking old cars. Each past 300,000 miles. One is only 150,000 miles. That one a listener gave me. These cars are, and people in them are continually vulnerable to bogus charges, paper crimes. And so only real crimes will be prosecuted and real crime cases created. That will cut, I believe if the judge agrees with my petition on what public offense means, that will cut criminal cases by 90%. And I know you're conservatives, and that might disturb you to think that, wow, we're cutting cases, because we know that we're all safer if we have more cases, right? Well, these are cases that really don't need to be in the courts. And so the first case in Chancery will attempt to make the law clear and get an order forcing the Sheriff's Department to use the warrant once again to protect all of us. We're middle class or upper middle class, so we don't have the worries that we don't have the worries that poor people have. But I've met many poor people. I interview poor people. I know poor people, and their lives are very, very hard. Not just bad food, and bad habits, but they're oppressed. They live paycheck to paycheck. They don't have savings. They don't have padding. They don't have gold and silver. They don't have vitamins. All of these they don't have. So that's case number one. The second case is my LPR case, which is I think it's magnificent. Again, because there is not a warrant, a reasonable suspicion against you personally. It has to be personal. Because there's not an allegation against you personally, because there's not one against you, they cannot create a research documentary ledger of a criminal suspicious activity, because that's what you're passing by that flock camera is suspicious and it's criminal, and we're going to just get enough information until we nail you. That's what they're doing. We have to remember how the gospel works. The gospel works by divine particularity. God chooses his children whom he will save, right? All the rest he lets pass by. They followed their own course. Salvation is particular. But there's also grace, by God's grace, is particular to every person he has deemed to save. But there's also general grace, right? Common grace. And in common grace, there are blessings to everyone. The worst axe murderer enjoys wine. The Israeli soldier who just sniped a baby in his mother's breast, he's going to go home and make love to his wife and have a great time, and he's real sweet to her. I mean, that's common grace, okay? But our law system requires particular accusation to operate. It operates on particular accusation that you, Greg, have stolen something, and we've seen you pass by that store. You seem to pass by that store a lot. There was a burglary there. We think maybe you're involved in it, so we're going to nail you. And the record that they make on Greg or you cannot be accumulated. There cannot be an accumulation waiting in reserve so that they can find the crime to attach to you, because that's what they do. That's what the Soviet Union did. Ron Unz recently had a post on he's the founder of American Conservative, on UNC.com, and it's called The Jewish Influence of USSR and USSA. And he points out that the United States and the Soviet Union, the former Soviet Union, have changed places. All the things that they did there with their gulags, we're doing here. There's a joke in Solzhenitsyn's book where one man tells people in the gulag officers, "I'm completely innocent, and I'm here for 30 years." And the guards laugh at the man and say, "Are you kidding? We know that if you're completely innocent, you're here for 10 years." So there's a reversal in despotism. We're operating under the Soviet-style despotism, which had far more leaks than ours does. Our leaks are great. Those are two cases that are pending. I'm planning on filing them very soon. I just have to get the legal reading done, which I do in the Flying Saucer building over in Hickson, the public library. People laugh. I'm in the Flying Saucer right now. I can't talk to you on the phone. I'm on my Westlaw. Another important thing, which I'm going to say is good news, and it's this. I believe we have found the way to deconstruct the administrative state. And the way of doing that is available to each one of us in a traffic case. Every one of us can use my theory, thesis, argument, theme, scheme, and claim to defeat a traffic stop. I've done it, and the matter is already in the Court of Appeals in Middle Tennessee and Jackson. The case is being brought by a very sweet African-American woman, age 77, Brenda Simpson, and she is challenging the entire structure of criminal traffic stops. Criminal traffic stops are an abuse of law, and she's arguing that she spent as a devout, sweet Christian woman, she spent 2 months and 4 days in Henderson County Jail on traffic charges. She was criminally prosecuted in 2 venues, charge stacked. One had 8 traffic counts against her, no license, no insurance, no registration. But she's using the road by right, not under privilege. She's not involved in privilege taxable activity as a Christian, and so she doesn't have all these commercial evidences like tags and licensure. And so she's being prosecuted. And her argument is this, that if the state is going to prosecute its interests against her under the motor vehicle privilege law, which is in Title 55, if the state is going to do that, it must follow its own procedures. It must follow the doctrine of exhaustion of administrative remedies. That's every interaction between the state and somebody in business or in privilege has to follow that procedure. The only exception for 80 years has been the use of the road for hire, which is what traffic is. Traffic is using the road in a commercial capacity, which when you have a license on your car, a plate on your car, or you carry a license, that's because you may use or are using the road for private profit and gain. That's why it's subject, without any offense to God or the Constitution, to regulation and taxation. Your use of the road is for private profit and gain, and so you have a duty to submit yourself to the state's Department of Safety for that purpose. Think about it just for a second. If people made a private profit gain in their trucking company without being subject to regulation and taxation, would that constitute a taking upon the general public? Yes? No? Yes, it would. That's right. So if you're making your private profit pounding the road with your heavy truck tires up to 40 tons, yes, you're subject to regulation, licensure, taxation, insurance requirements. But if you're using the road privately, as Miss Brenda, as a pious, sweet Christian woman does, why does Grandma have to have a license? Why does Grandma have to register her car with the Department of Revenue if she's not using it for private profit? So the Miss Brenda's argument is my conviction by an ignorant jury was improper, and it was invidiously discriminatory as against me because I'm being prosecuted under the privilege law in Title 55, and the state went straight to criminal court. Well, that violates many things. The state has to operate in the department it created to regulate traffic, which is safety. So her argument is essentially every traffic case has to be heard in Nashville. The administrative state views her as a nightmare, absolute nightmare, because they've never done it that way. They've always prosecuted privilege allegation cases in criminal court, never in the administrative court. So if you're a plumber and you screw up, you abuse your privilege. If you're a plumber and you're making professional mistakes in your privileged occupation, well, you're brought up you're not taken to criminal sessions court. You're taken up by the contractor board, and an allegation is heard civilly in
privileged occupation. While you're not a criminal.
She likes you.
Your hearing on your misuse of glue and PEX pipe is not in criminal court. It's in front of the contractor board under the UAPA, the Uniform Administrative Procedures Act, and that's how controversies are settled. They're never settled with arrests, tasings, people being dragged out of their plumbing van for abusing the glue, the glue gel. That's not how it works. And driving and operating a motor vehicle constitute a privilege no different from plumbing, hairdressing, real estate appraisal, surgery, you name it. We have about 50 professions in the trades and in the healing arts. And every one of them has a board to regulate civilly, like Christian people, civilly regulate an allegation that your doctrine was screwed up. They don't come after you with police. They don't do that. And so she's saying that if the system's going to operate on grandmas like she is, it has to be civil, it has to be administrative, and it has to be the proper authority. And one way to look at this is the separation of powers doctrine that we got from Montesquieu back in 1748 in his book of the laws. He said, he was a revolutionary, okay, but he thought we can maybe win conservative affinity to our program by saying, let's divide government up. Legislative, executive, and judicial. That's what we did. The theory doesn't work, but that is the theory. How is it that if I violate the traffic law in Title 55, that I'm not given a referral letter by the Sheriff's Department about my taillight, who says we're sending this to the Department of Safety, and you're gonna hear from them about your taillight because you got to get it fixed. That's all that he has authority to do. Brandon Bennett, the deputy, should not have arrested me. He should have referred the matter to the proper authority under the executive branch. So what happens is you have the Department of Safety over in the executive branch serving the public interest, the public health, safety, welfare, and morals. And so if there's a wrongdoing alleged in that field of privilege, well, it's heard here under the commissioner in the commissioner's court. Hearing officer is called, the court is called a contested case, and that's where the case is heard, and they're settled. But what they do is, over here, executive branch, here you have legislative branch, here you have judicial. What happens is, a violation of the separation of powers, the judicial branch, the DA, crosses over here and intervenes in the process. The commissioner should be hearing about that taillight, and yet the judicial branch jumps over, intervenes, and tries to handle the matter criminally and judicially when it's supposed to be handled administratively and civilly and under civil law over here. So they're violating the separation of powers. Very powerful argument that we've developed here. My time is low here, so I want to save the balance of it for answering questions. And anyway, this exhaustion theory is taking interest across the country. And I'm promoting the idea and explaining the idea on TikTok. I'm a reporter in the radio business, and I'm not on the air right now, but plan to be back on the air by God's grace soon. And I'm on TikTok, and there's a lot of interest in how this works. So if you go to TikTok, you'll get things that suit your interests, okay? So I'm the smartest guy with bow tie on TikTok, and you can see my reports there. All my theory, when I'm working on something, you get a minute here and a minute there, a couple minutes, and I explain what I'm doing. I give you the legal basis. So people say that they're getting kind of a law education from my discussions on my cases and your cases. I'm always interested in your case because I can help you. And since we know each other, you may have my card. Ask me what I would do in your situation. I'm not an attorney. I don't practice law. I don't give legal advice. But under our press rights, under our assembly rights, under our free speech rights, we can always consult together to figure out what to do to end oppressions. And if you have a particular oppression in your case, well, maybe you can try out my ideas. I mean, I'm always wanting to help people use my ideas to their benefit. Other question? Just speak up, ma'am.
Okay, so my grandson has a little contraption called a flipper, and if he goes to a restaurant, he can turn the TV off, or he can do different things to TVs and computers and flop cameras. If we were to use that to confound would that be against the law? I mean, I know you're not a lawyer, but you know if we would have a case.
Can you repeat the question?
The question is, her son or son-in-law has a device called a flipper, which gives some control over other devices, and is that against the law? I wouldn't know. I haven't done the reading on that. I couldn't say.
She said they can turn off flock cameras.
Turning off flock cameras. I know there are devices called sawzalls, which are able to cut steel. And many posts on TikTok are about people using them to cut down these poles. That's entirely understandable. My goal is for as my complaint points out, it's not how bad this is, how many there are. There could be thousands, there could be one. Constitutionally, I have to show in court for sufficiency of the complaint, I only have to show that there's one pole. And I want the judicial order to be effectively a sawzall against the base of that pole. And it comes down by an order from the court, because that order cuts off every pole. Okay, we don't want individual poles here and there to come down, which is, no one's going to object to that. But I think the operation of law is where we're going to find our security, not in maybe violent, personal vendetta, revenge, anger, which is not wrong, but we want to make sure that if we have that anger in our breasts, that it be a righteous anger, and that we use and avail ourselves of the law itself. Because don't forget, when we use the law and uphold the law, we are magnifying our protections. We're making our legal protections significant. We're holding them up. We're saying, look. If I just go in the dark and cut down a pole, I've not done that. I want to declare in court, representing you and all people in like station, I want to be able to say the law is important. And Your Honor, here it is. Look at these magnificent quotations from our Constitution. Look at the court cases that talk about the limits of search powers, the limits of arrest powers. So again, the law has to operate individually against each one of us, and the mass surveillance is absolutely prohibited. And the premise of mass surveillance, I suggest, is prohibited in our state constitution. I don't plan to use the Fourth Amendment much except as an alternative argument. I plan to rely on Article 1, Section 7 on searches. And general warrants are dangerous and ought not to be granted, the provision says. So we are under general warrants generally, and LPRs, license plate readers, are also general warrants specifically. And they're high tech, and we can stop them at the root. We need to go down to the base of the tree and chop, not just, where it's convenient, 3 feet above the ground with my saw conveniently cut. We want to go down to the grass, and we'll go down underneath the concrete blob that they put that pole into and dig the whole thing out. And that's done by an operation of law. Question?
In answer to your question, a politician running for office in Nashville shot a flock camera, if not one, maybe more. He was arrested, and he can't run now because they said, no, we're not going to help you run. So he was arrested. I don't think it would be a good idea to.
No, I'm
To mess with
saying, I'm
them.
saying that if you have a constitutional right to not be surveilled, then you have a right to protect yourself. So that's why I think that if
Surveillance is against the law.
then protection has to be law.
Right. I'm lawfully exercising my rights to extend a shield around my car as I'm passing by the camera to disable it when I pass by. All power to you. I'm not going to object, and I'm going to honor and praise the man who thought of how to do that.
I just thought of something that I wanted to throw out there and see your reaction to it. I love what you're doing and wish you all success. And see, it's an idea about an act of civil disobedience. I'm wondering how many people you need to sign up for this for it to work. And that would be that if you got as many people as you could nationwide to put maybe a yellow piece of paper over their license plate and something like, this will be removed when the unconstitutional blah 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 is completely repealed, all equipment is destroyed, verified, something to that effect. And everybody did, like thousands of people did it, starting on the same day.
Okay, thank you for the question. Protest has no real effect. I believe.
Civil disobedience, not just protest.
Well, protest, and even if people all civilly disobey on Halloween night, as some have proposed on YouTube, that all on Halloween are all wearing gorgeous uniforms of masked bandits and whatnot and goblins, and we're all on the street. We're gonna carry a little sawzall in our plastic bag for goodies.
But this is actually violating the law.
Yes. Well, for one, I can't make that happen, and I don't see waiting on people to somehow gather together to do this, and I don't think we have to. We're busy. People are busy, and what has to happen is a proper petition needs to be made, understanding what our rights are, and putting it into it that way. That's why I've always worked on my own. I've never had groups of people join me in filing. When I go to the clerk's office to file, I've often thought about, wouldn't it be great if I had just a room full of people, all, Saudi Daisy people, all excited about David Toulis. He's filing this important lawsuit, and isn't he our hero, and that kind of thing. I don't have time to organize that, and it's not really necessary. What is necessary is that you make the proper petition of the law. And that's how we need to end these things, a proper petition by a proper party. And I'm showing standing.
You can do that at the same time.
Doing it at
But
the same time.
Courts are influenced by public opinion.
Yeah.
So it would be a way of
There's power in
educating.
numbers. There is power in numbers.
It would be a way of informing most people who don't even know what a flock
I
is.
like what you're saying. As a journalist, I know how to write press releases. I write very good press releases, and every time I have a major event in a court case, I send out a press release, but I'm blackballed by all the press. John Wilson at Chattanooga.com, I'm a non-entity. The Times Free Press, which was recently sold after losing 25 years of losing
Why
money.
it be a podcast, not legacy media.
I'm on TikTok, and I'm also a blogger. I have a law blog, but again, these are I'm the least read journalist in Tennessee, for sure, the least read. But I hope, by God's grace, to be the most consequential by understanding things correctly and having my own, since I have standing, have my own foot in front of the court to stand there in front of him and say, Your Honor, you have a duty under our law to protect me and everybody else. I always sue on behalf of the people. Just one more case that's going. I have 3 lawsuits against the Commissioner of Safety and/or Revenue to end universal mandatory auto insurance. That's another time we can talk about that. But I have a hearing. I had a hearing Tuesday in front of Judge J.B. Bennett. He's a circuit court judge. By interchange, he is serving in Chancery Court, hearing my case. It arises from a 2.5-year case in the Department of Revenue, and I have a deadline September 15th to file the draft order I want to have happen. I've already submitted a draft order to end universal mandatory auto insurance as a corporate capture rogue oppression system of extortion of the public.
Yes.
It is extortion of the public, benefiting the insurance cartel to the tune of $2 billion in free premiums every year, of premiums that otherwise probably would not be paid to that line of service. In the Tennessee Automobile Insurance Plan, all insurance companies have to be part of that plan, and then they can participate in this racket. It is a racket, and we have shown beautifully, in beautiful filings that you can read on my website, of how this is a rogue program apart from the law. So the order is due on the 15th, and the judge is going to take it under advisement. I have another case on the same issue in the Court of Appeals. There, the merits of my claim to end this program against roguery in office is not directly in front of the court. The question there is, do I have to exhaust administrative remedies to be heard in suing 2 commissioners? And my answer is that I don't have to exhaust my administrative remedies because I'm suing 2 commissioners for breach, and nuisance is not part of state sovereignty. The state's sovereign authority does not cover for nuisance, the cases say, or in this case on insurance fraud, misfeasance, misconduct in office. So that case is going to probably go back to Chancellor Martin in Davidson County for a real hearing on the issues.
Just as a side note, we used to be able to spray the license plates to block some of the cameras, but the block cameras now use advanced infrared sensors and high contrast imaging that easily reads through aftermarket codes. So these cameras are a lot more advanced than the ones we were dealing with before.
I guess you all heard that. There are limits to protecting yourself. Important in my court case on Flock, which will be filed in circuit, by the way. One case in Chancery, the other case in circuit. I want them separated because I don't want them to be merged, because they're 2 distinct legal issues. But if you are compelled to have an identifying tag on the back of your car, that cannot be considered as waiver of your rights to be on the road privately without continually signaling who you are. Right? If you don't have a tag on the back of your car, no one really knows who you are. But if you have to have the tag under compulsion, they can't then say, well, that's consent, and therefore, since nothing in public is private, you have already consented to being surveilled and to being monitored. They're using the tag for their convenience. Again, without the tag, their job would be very, very hard because they'd have to use descriptions of cars, and they wouldn't have an easy way of connecting a particular car, with a home address and details of the person who made the application for the registration. Yes, question?
I was listening to Man in America, and they're using there's a different type of, it's not flock camera that's coming up, it's some other kind of camera that's on a platform that's solar panels. Are you familiar?
There are advances, but I'm not concerned particularly about them, because again, it's not the misuse of these programs nor their proficiency in gathering data that is the issue. No, the issue is the first camera that went up in a criminal ledger creation program digitized. That's the only question I have to worry about. But there are, and if you're on social media, no doubt you are seeing these reports about them being able to read your dog collar. If you have a heart monitor that Dr. Adams may have consulted with, they may be able to read that too. And your earbuds, your phone, there are all kinds of things that they can read that are electronic. Again, they're totalistic in their view. They want to monetize everything. They want to criminalize everything they can. one of Lenin's notorious Jewish authorities was Beria. He was in charge of the police, and he had a very famous statement, usually attributed to him, in which he said, "Find me the man, and I will find you the crime." So just identifying you, they can engage in a process called reconstruction, data reconstruction. In other words, they can create a parallel case. They can illegally surveil you, and they can construct what would seem to be a more reasonable case against you based on things they are lawfully allowed to obtain. It's called parallel construction. Parallel construction is where they illegally surveil and condemn you and go after you for some reason or other, but then they have a reasonable, ordinary analysis that they offer to the court showing how we came to this, this unusual information about this person's doings. Other question?
On the example that you used of this case against this grandmother, if in fact the courts ruled that the Department of Safety pursue this violation administratively, so practically speaking, if it was then thrown back to the Department of Safety, they would issue something, would they not, saying that you are responsible to have a license, and we are the ones that enforce that, and so.
Yes, that's correct. The Department of Safety has full authority over traffic enforcement. If you have a license or registration, you are subject to the Department of Safety. Your license is issued by that department. And
but the fact that it's unconstitutional, is that the broader thing with regards to a suit like this, is that once it's thrown back to them, then the other branches might pull in and say,
no. No. If traffic is administered by safety as it's supposed to be, many cases don't show up in the judicial branch. In other words, if we have 5,000 criminal cases that are heard criminally, that are later after Ms. Brenda's case goes through,
are you saying they can require that lady to get a license?
No, they can't. No, she's not involved in commerce. She's not using the road for hire.
That's what I'm saying, but that's what they would. Oh, so they wouldn't even try to do that.
If she's not involved in commerce, and the officer who made the referral to Department of Safety doesn't have evidence that she was carrying goods or people for hire, then the Commissioner of Safety has no subject matter jurisdiction.
Okay.
Yeah, her argument in court is that the court doesn't have subject matter jurisdiction because the case is improperly before that court. The case should have been heard and should have been taken by the state itself into its own Department of Safety for administration. The rule is generally cases and disputes are administered, then they're adjudicated. Adjudicated simply means they go to court, right? They go to court after they're heard administratively. And so that's what Ms. Brenda's saying. She's saying effectively that all traffic matters are improperly in criminal court. They have to be heard by the commissioner, who needs to get up off his duff and open courts to hear traffic allegations that are his job. His job is traffic. And traffic is all use of the road for hire, and we all apply for the driver's license for hire purposes. I mean, that
So do you think the Department of Safety would have foregone the requirement? Do you think that the Department of Safety would have foregone, if they were the ones handling it, they would have foregone the requirement for her not operating commercially to have a license?
That's an excellent question, and the answer is yes, because the jurisprudence on administrative agencies is that they have specialized knowledge on their fields, whether it's conservation or medical or other. And here, Department of Safety knows the limits. The Department of Safety knows that it's in charge, and its troopers are in charge only of commercial use. They don't have any authority over private use. Now, we're dealing here with a problem that you're bringing up, and we don't really have time to get into it, but the problem is that these divisions of government falsely commercialize all use of the road.
Yeah, that's what I'm really.
They falsely, it's called legal fiction. They're involved in a legal fiction that is court policy. The legal fiction is judicial policy and also administrative policy. And Ms. Brenda plans to challenge in her second appeal. She has one case already gone through the whole appellate process. She's awaiting oral arguments. In the second case, she indicates that she's going to be challenging the whole fraudulent presumption that no use of a road can be private. It's a presumption defended by many court cases in which her issue has been waived. In other words, the challenge she's making has been waived by other participants in these disputes.
So the broader strategy is multi-pronged.
Yes, well, my goal is to end the criminal traffic stop and also have grandma to be free from regulation of any kind. Since grandma is not a participant, you're not a participant, your wife's not a participant, no one here is a participant in the logistics, shipping, hauling, trafficking, trade, or business. If you are, well, you're under the Department of Safety for the right reason, right? And so we want grandma to be freed from the obligation to register as a commercial person with safety and go to the Department of Revenue and get the registration. A registration tag converts your automobile into a motor vehicle. Motor vehicles are not bought and sold in car lots. Automobiles are sold in car lots. But in the process of conversion, a legal action, the automobile is converted into a motor vehicle. Motor vehicle is a term of art, it is a legal construct, and it describes the car used as an instrumentality of commerce. When your car is used to haul goods or people for hire, for pay, you're getting paid, that is not a car anymore, that is a motor vehicle. So that could be a trailer, it could be an automobile, it could be a pickup truck, it could be a straight body van, it could be a large truck. Those are all motor vehicles used for commercial purposes. You know, and we have again the presumption that all use has to be commercial. And if Grandma, Mrs. Simpson, is on the road without these papers, we're going to criminally prosecute her. We're going to put her in jail. And the fact that she didn't pay for the registration or the license is a loss of less than 1 penny per day to the state. 1 penny a day. So over 3 months, the state has lost $1. We have another question.
So Tennessee law 55-4-110B requires a license plate to be clearly visible, clearly legible, and free from foreign materials. More importantly, it expressly says no tinted materials may be placed over a license plate, even if the information upon the license plate is not concealed. A violation is a Class C misdemeanor, and that was passed by our Republican majority up in Nashville. So our Republican representatives are the ones who passed that. And then also license plate flippers are illegal thanks to Greg Martin, our local rep also. So just keep those in mind. So like if you put something over your plate, like you would get a Class C misdemeanor for that. So you just have to be willing to go through the process that this other lady's going through, similar, where you're gonna legally fight the legality of these laws. But I was gonna ask you too, how can we follow these lawsuits that you're placing? How can we follow how things are going?
You're a sweetheart. You're a sweetheart. I'm a writer. At the moment, I'm not on radio, but by God's grace, I'll get back on the air. But the name is davidtoulis.substack.com. So David Toulis has one L. I have a card here, and I can give you my card. from, just ask for it afterwards. davidtoulis.substack.com. So all my filings go there, and a lot of stories about other people involved in these issues. I'm trying to start a counter-revolution. The revolutionaries are inside the gates. They're like the hankfish that eats out its victim from the inside. And that's what's happened to us. We've been eaten out from the inside, and we're flipping along in the water, but we don't realize that we're dying or we're already dead. The counter-revolution is premised on Christian liberty, the absolute sovereignty of God. We are under a curse and wrath. God hates us. Okay? Jesus doesn't love us. Okay? He doesn't love us. He hates us. I'm not talking about you individually. I'm talking about the American people. And we are under a deliverance as against us. We are in a servitude. We're as bad a servitude as the Israelites in Egypt, or under Assyrian occupation, or Assyrian depopulation. You know, in the old Mideast empires, you were physically removed to the other place so that you could produce crops and pottery for the Phoenicians. Now, the alienation is not a physical relocation. It is by the alienation of your rights from your person. Your rights are separated from you by all kinds of things that you agree to. And their misuse of their own law lets them continue the process. My theory is nailing their tongue to the table. If they want to have an administrative state apart from the Constitution, and if they really want to commercialize everything, let's give it to them. And that's my whole exhaustion theory premise is. Their law says they have to administer all privileges in the same way. Their law says that if I'm involved in a privilege and I violate my professional ethics in the enjoyment of that special favor, right? A privilege is a special favor. If I violate the rules that I agreed to, well, then I have to be held to account, reasonably so, right? There's nothing wrong with that. So, well, where? The question is, where is the state going to hold David Toulis or you to account for your misuse of your car? You were speeding 15 miles over the level, and an officer saw you do it. Well, you need to be held to account. So you're going to get a letter from the Department of Safety indicating that that officer swearing an oath on a statement that says he saw you traveling this much over the speed limit. That's going to be heard in the proper department. Since that proper department doesn't do its job right now, the fact that the judges are trying to figure out how to make this work, they're going to have to say, all right, safety gets 500 new judges to handle traffic cases. Suddenly, criminal cases drop in every municipality and county because people are no longer being accused of being criminals. Think of all these poor people. Old cars, they don't have insurance. They're beleaguered. And our country's going down thanks to Republicans and Democrats. We're being decapitalized. We're being enslaved. Inflation's eating away our savings. We're being ruined by government. And so let's make the administrative state operate according to its own premise. Nailing their tongue to the table is my colorful description of that process.
What's your take on the practice of law enforcement buying data from data services? Do you agree it should be illegal, and how could it be enforced if it was banned?
Okay, I guess your other question, is it legal for government to do indirectly what it's not allowed to do directly? And I would say that no, government should not be a client of private data brokers. This is an uphill battle because big tech and big government are intermingled and intertwined. Palantir, Elon Musk, all these high-flying people with their the Ellisons with their high-flying tech companies, they and government are the same. So we kind of live under a technocracy, not a Republican form of government. We've lost all the things that our founding gave us. Those things cannot be restored. They will not be restored. And so I would say that the order from the court probably won't address that question of can they use private data. The order's not going to go that far, and I don't know that I can really ask for it. Anything else before y'all head home? Again, on TikTok, it's smartest guy with a bow tie. You guys, when I went on TikTok a few years ago, I said I'm not going there because all I get are young girls in bathing suits. Now, when I went back a year ago or so, all I get in my feed are things that interest to me. So it's all about court cases, it's all about traffic stops, it's all about legal principles, people who have legal theories, or they're pontificating like I am about where we are, what we can do to help ourselves. I'm there to help people, and I have a few followers. And then davidtoolis.substack.com. It's free. Toolis has one L, and that way you can, if you want to read how these things work, those things all show up on my report, because my reporting may sound legal, heavy legal content, but if you want to have liberty that you want to defend, like the freedom of not entering into a contract with an insurance company, it's good to know what the limits are, and can anybody force you to enter into a contract with an insurance company when that party has no authority to use law leverage to force you into that contract. And that's, the law doesn't require insurance of all users of the road. The only people who have to have insurance to use the road in Tennessee are people under driver license suspension, period. They're the only ones who have to have a special insurance called the motor vehicle liability policy. It goes with the SR-22 form, which is called a certificate, and the whole body of law at issue is about qualifying accidents and showing your part in that accident. And the other part, the whole main body of that law, is about the suspension program. If you're under suspension, you get to keep the privilege, though you are deemed irresponsible, though you are deemed dangerous, you're a high risk. You still can use the road. Why? Because the road is essential for your life. So the Department of Safety will give you your license, but you have to have continuing security. You have to have continuing proof of financial responsibility. That is to say, you have to have this high-risk insurance that is merely, in the end, it's merely an owner's or operator's policy that has the certificate. So, but you can't be forced generally unless you have been shown to be irresponsible by safety or court. They can't force you to buy insurance. And I'm in this case because, being poor, I didn't have insurance on 2 cars. And so I said, okay, well, I guess I have another court case to deal with. Anything else? Thank you so much, Ms. Glenda, for having me. We have one more question. You want to hear this? Hear the question? Okay.
I think I have 2 questions about this mic. Penny,
Can you hear me?
Yeah.
Forgot what I was gonna ask. Oh, so now is this Tennessee law only, or is this across the board? Georgia, Alabama, Ohio, these laws that you've been stating, are they Tennessee laws only?
My insurance case is about Tennessee law. My lawsuits are about Tennessee law, but the principles that I'm explaining are really applicable in every state. And my pleadings are very, very muscular, very much to the point. I don't have any wasted, no gaseous rhetoric, no big reports or anything like that. One lawsuit filed by the Institute of Justice in Wichita against the LPR system, there was about 400 cameras, ran to 40 pages. I mean, I'm getting all in about 20 pages. And I don't have to prove, like I said, the misuse, the scandalous abuse by cops of these systems is not judicial material. What's judicial is, what does the Constitution mean? What does it say? And is there one poll and one program in the jurisdiction in which I'm suing? But of course, as a publisher and a writer, I'm promoting my work and my insights as much as I can, suggesting to people in other states that they may in fact have, on insurance, they may in fact have a financial responsibility law and not a mandatory insurance law. I think Georgia, it's a financial responsibility law, and yet it's enforced that if you don't have insurance, we're going to take you off the road. And that's someone in Georgia has to deal with that. That's not, I can't deal with that. Anything else? Thank you.
Thank you, David. That was great.